We're back today with our second podcast with Thomas Windsor and Tobias Bend from German law firm Gleiss, Lutz. And today we're speaking about the end of employment. So Thomas, Tobias, what protections against dismissal do employees enjoy that employers need to be aware of?
Yeah, as a starting point, I believe at least that Germany has a reputation for being very protective in relation to termination of employees. And this is probably true, but keep the magic number in mind, which is 10, which means, the very strict protection only kicks in if you employ more than 10 employees in an operation here in Germany. And if you are below this number, you are generally free to terminate people. You just have to comply with the stipulations of the employment agreement. Of course, the termination must not be arbitrary. You must not terminate someone because of his age or his gender, etc. But that's typically not a protection. But the rules are much different when you are going beyond the 10 employee number, because in such a case, you would require a sufficient ground to terminate an employee, which would be misconduct, redundancy, or anything linked to the person which doesn't make him her able to perform the duties of the job anymore. And you would require such grounds even if you comply with the notice period. So it's really about ending the employment relationship requiring a sufficient ground. And if you don't have such ground, in many countries, it's only about money. Yeah, how much compensation do you have to pay if the termination is regarded as unfair? But in Germany, the legal consequence for not having sufficient ground is just reinstatement. That's what is provided for in the law, and that is very unique, I believe, in comparison to a lot of other jurisdictions.
That's very interesting, and certainly the reinstatement issue will be one that is a particular concern, because although it is possible to have reinstatement in the UK, it's in practice very rare. So it sounds as though it's more common in Germany.
Well, as I said, it's a legal consequence. I would say in practice, in 90% of the cases, there is a settlement. The employees accept the termination. The employer pays a certain severance, and the parties part ways, if I may say so. The claim to reinstatement, which is, let's say, really the legal consequence, basically sets the scene for the negotiations on the severance package. And the problem for companies is that it's very hard really to estimate what the potential settlement amount, severance pay, might be, because there are no rules defined in the law how to determine this amount. There is no maximum. It's really about negotiating with the individual employees and keeping in mind, if the employee is successful, he could be reinstated. The only hope is that a lot of employees who are entitled to reinstatement do not want to be reinstated. And I remember one case I had, when an employee finally won the lawsuit, she broke down to tears because she realized that she had to get back to the company, had to get back to work, and she didn't want it to, but she was too eager, wanted too much money, and the company said, I don't pay this amount. She eventually won, but did not won only legally and did not achieve the result she wanted. But as I said, the big problem is that there is a certain uncertainty as to potential costs of a termination, because you just don't know for sure beforehand.
Yeah, that makes absolute sense. And I suppose it naturally leads into the next question, which is, in the UK, employees with over 2 years service have protection against unfair dismissal. So there are relatively limited circumstances in which a termination can be made fairly, and there has to be a fair process. But, and that's the key but, compensation is broadly capped at 1 year's salary or about £90,000. Because of that cap on compensation, employees often bring a claim for discrimination because it maximizes their potential compensation. It sounds as though you don't have quite the same issue regarding discrimination claims in Germany, based on what you've just told us about reinstatement and calculating compensation.
This is correct, because there is actually no need for this protection. Generally, I would say anti-discrimination law is a bit underdeveloped in Germany in comparison to other countries like the UK or the US, because employees already have sufficient protection under the law I described, and any compensation not being kept, and that's why employees do not have to move into the, let's say, discrimination arena, because they are already protected. Of course, a termination would be invalid, if the employee is terminated due to protected criteria like age or gender, etc., and this may give claims to additional compensation, but this would be rather small amounts, and therefore there's really no, let's say, commercial benefit for the employees to move into discrimination. Usually it's just sufficient for them to say, my employer did not have sufficient grounds to terminate me from the start, and therefore they don't have to prove that there was any discrimination involved.
That's really interesting, and clearly a big difference from the UK, so very helpful to understand. So let's take a slightly more depressing example where an employee has done something very badly wrong, so perhaps some very serious misconduct. Can an employer terminate for cause in that situation? In other words, can you terminate with immediate effect? Is that how it works in Germany?
Yeah, that's how it works also in Germany. So we differentiate between terminations for good cause, i.e. with immediate effect, as you mentioned, and on the other hand, ordinary terminations, just complying with the applicable notice period stipulated in the employment contract or under statutory law. Termination, however, for good cause, i.e. without a notice period, is only possible in severe cases, e.g. stealing of company property, and such termination terminates the employment relationship with immediate effect. In absence of such significant grounds, severe cases, e.g. stealing company property, an ordinary termination may be issued to the individual, and as already outlined by Thomas, such ordinary termination requires a justification by either operational reasons, i.e. redundancies, conduct-related reasons, that would be misconduct you mentioned, and as a third but rather theoretical option, personal reasons such as inability to work or long time illness. And as regards an ordinary termination for conduct-related reasons, an employer should be aware that under the law, as a general rule, at least one prior formal warning must be issued to the individual prior to issuing the notice of terminations.
And one additional aspect, if I may add, to be kept in mind, is that we don't have what we call absolute grounds for a termination. So even if an employee was stealing from the company, you would still have to conduct something what we are calling a balancing of interest. So if the value of the stolen good is very small and the employee was working for a very long time with the company, has not caused any problems in the past, always complied with the rules, then the courts may come to the conclusion that although the employee was stealing in this particular case, based on the overall assessment, the notice of termination is invalid because the balancing of interest spoke for the continuation of the employment relationship. And this is also sometimes something to be, or it's hard to explain sometimes to clients that although someone was stealing, they still might, be successful in court.
Thanks for that. And that's interesting, because I think it isn't too dissimilar in the UK. There has to be very extreme circumstances before you can kind of summarily dismiss without notice. And we would normally say that, there should at least be some investigation and possible warnings. But Tobias, you mentioned notice, giving notice of termination, so something that's set out in the contract of employment, and that's obviously a position that's the same in the UK, that we have these notice requirements. But in the UK, we can also, an employer can often put an employee on garden leave or pay in lieu of notice if the contract provides that. Do you have similar concepts in Germany?
Yeah, we have a similar concept also in German employment contracts. Typically, notice periods are stipulated. We have some minimum notice periods in statutory law, but which range from 1 month up to 7 months after 20 years of service. But employment contracts, for instance, provide for 3 months notice or 6 months notice, something in this range. During the notice period, an employment relationship technically stays in place. So the employee stays on the payroll, is entitled to the salary, and any bonuses that she would earn during the notice period. But as a general rule, after a notice has been issued, the employee can put the employee on gardening leave. And during such a gardening leave period, the employees would be bound by a non-compete obligation, would still receive the salary, of course, as mentioned before, but would not be allowed to work for a competitor. And in particular, if someone, is working higher up in the hierarchy, has access to important business secrets, etc., typically companies, would send those people on gardening leave just as some kind of, let's say, cooling off period. What would not be possible unilaterally, at least, is to make a payment in lieu of notice. So if the employee does not want, he just continues to be an employee during the notice period, receiving regular salary, etc. And employees would typically only agree to a premature termination of their employment, i.e., prior to the expiration of the notice period, if they have some employment lined up for the time after the termination of their employment relationship with their current employer.
So, in terms of other things we should think about in terms of dismissal, are there any particular groups of employees who have special protection against dismissal under German law?
Yes, indeed. So we have some group of employees enjoying special protection against dismissal. However, that does not mean that such individuals may not be terminated at all. However, some, let's say, formal steps are required to be taken by the employer. For instance, there might be approval requirements by relevant state authorities. And to give you some examples as regards the protected groups, these are groups of severely disabled employees, for instance, pregnant employees, employees on maternity leave, on parental leave, as well as members of a works council. And then we have restrictions regarding terminations for employees in certain functions. For instance, a data protection officer enjoys a special protection against dismissal. And in some parts of Europe, there are also employees with protections who are, apart from their employment, a member of some kind of local government.
That's very helpful. And I suppose this brings us on now to a topic that is obviously pretty distinct from the UK, although we do have this concept in the UK, which is works councils. I'm aware that works councils play a really prominent role in employment in Germany. When employers are considering dismissing an employee, do they need to involve works councils?
Yeah, so the Works Council will be a topic of our third podcast, but with regard to the involvement with regard to individual dismissals, that's correct. An employer is obliged to inform and hear the Works Council prior to each individual dismissal. This is a precondition for the validity of the termination. That means if the Works Council, if one exists, of course, is not heard, the termination is just invalid. However, as mentioned, that's only an information right of the Works Council, and the Works Council has no veto right with regard to the termination.
But what one may add is that the complying with this hearing obligation can be relatively complex, because all the reasons for the termination must be presented to the Works Council, and there is very strict case law, which facts the employer must present to the Works Council, and the general requirement is that the Works Council must get comprehensive information to really evaluate the case and to form an opinion, even if the Works Council does not have to approve the dismissal. And very often, as a practical matter, very often employers are not able really to comply with the standards developed by case law in relation to such Works Council involvement, and there's a lot of work, thinking about your UK clients. If they had to involve a German Works Council for a termination in Germany, they should really plan for sufficient preparation, to prepare such Works Council hearing.
Very good advice, and definitely worth allowing time and thinking process to understand what might be needed in those cases. So moving on to the final question, which is, okay, you've got as far as a dismissal. Are there any particular practical steps that employers should think about when trying to resolve termination disputes in Germany? So by way of example, can you offer a severance package in return for the employee waiving their rights under a settlement agreement?
Yes, you can, and you should, would be the short answer. So typically, employers would, when planning a termination, a dismissal, would really aiming at a settlement at some point of time. So usually employers would not aim at, I want to fight this dismissal through because of all the restrictions and all the potential problems you may see, and the consequence being reinstatement if you're not successful. The big question is always, how do you achieve such a settlement in the most efficient manner in terms of time and money, obviously. And one decision to be made, in my view, is whether you talk to the employee first or whether you issue notice of termination first and start to discuss thereafter. This really depends on the role of the particular employees and, of course, maybe his attitude and how he or she is approached best. For instance, for some executives, it's in their interest if they could later say, I was not dismissed. I agreed with my employer a voluntary departure from the company. And in such cases, it may make more sense and may fit culturally better if you talk first and say, it's time, to part ways. Here can be reached an agreement, and often it is possible with such people to reach an agreement. This may be different for, again, the example of the maybe shop assistant, where you wouldn't maybe not start with a negotiation on a mutual termination agreement first, but would rather issue a notice of termination and would try to reach an agreement afterwards. because sometimes it's important to really get the message across that the company has made a decision to terminate someone. And how could you do it better than by issuing a notice of termination? But it's really important that you think about how you would want to structure this process. There's really no, let's say, legal rule in this regard. It's really about developing the right approach for the particular person and particular situation. And if you're reaching such a settlement, the main content obviously would be that the employee accepts the termination and the company provides a certain severance package. You know, typical points you would negotiate would be the termination date. So sometimes employees say, you know, if you terminated me a little bit later, that would be helpful because I would have more time to find a new job. And as mentioned before, during such prolonged notice period, you could put them on gardening leave. Then in addition to that, the severance pay is obviously the biggest part of the negotiations. There is no statutory rule for calculating such a severance. In practice, the severance is usually calculated and negotiated around the formula factor times monthly salary times years of service. And the factor usually ranges between 0.5 to 1.5, which eventually means that usually you would agree on a severance which ranges between half a monthly salary up to 1.5 monthly salary per year of service. But as I already stated before, there is no cap. Employees may just say, I want to have 2 or 3, and the highest demand I once received was actually 5 monthly salary per year of service, but then the answer was pretty clear. Well, I don't think that we are able to reach an agreement here because there's just no basis for negotiations. And, you know, setting, let's say, clear red lines for your negotiations is also important for the employer. And if the employee is not willing to accept the termination, you may just have to go through the dismissal process and try to reach an agreement later on. And maybe one final remark as to particularities here in Germany. What we usually learn from UK to US clients is that, you know, they want to avoid being in court basically at all costs because, you know, being in court, having a court proceeding does not feel very well. In Germany, after the employee received a notice of termination, they have 3 weeks to file a complaint with the labor courts. And if they do not file a complaint against the dismissal, then the notice becomes valid automatically. So they are actually forced to initiate such a court proceeding. And I would say it's rather typical that such dismissal disputes end up in court, but you know, usually, again, 90% of the cases are also settled during the court proceedings. And one thing which is probably really different from the UK and even more so to the US, that you know, court proceedings in Germany in the labor courts are less expensive than in the US. So we don't have disclosure, we don't have this discovery, and it might be possible, you know, to reach a settlement, to reach an agreement with the employee, also during such a court proceeding without causing too much additional costs.
Thanks for that. That was really interesting, and yeah, I think we definitely agree that everybody wants to try to avoid going to court if they can. It's certainly it can be a really long and costly process from an employer's perspective and an employee's perspective. Not a pleasant process to go through. So that wraps up our podcast on termination of employment. And I think it's quite clear that there are some quite substantial differences between Germany and the UK when considering terminating employment. So thank you both. We'll be back in our next podcast covering collective consultation issues.
Thank you very much.